session. Please be seated.
Yeah, we might need to do that. You call the last case for the morning docket.
Kenneth W. Barnett versus State of Tennessee.
Good morning, may it please the court. My name is Autumn Bowling. I'm from the Knoxville Bar. I represent the petitioner appellant in this matter. We're here on appeal from the denial of a post-conviction relief from Knox County Criminal Court Division 1. I'd like to reserve 5 minutes of my time for rebuttal, if I may.
All right. 5 minutes.
Thank you. We've raised 3 issues as to the denial of Mr. Barnett's petition for post-conviction relief, and what I would like to do in guiding my argument today is to actually start with the 3rd issue that we have briefed, and then come back around to the 1st and 2nd ones. And the 3rd argument is that the post-conviction court erred in finding that the trial counsel's cross-examination was based on adequate preparation and therefore not deficient. And I'd like to back up a little bit of somewhat of a broad point, is that in a criminal case, just because when we see a case where the jury does acquit on some charges, it is a win. But just because you get some acquittals doesn't mean that there weren't errors or that counsel could not have been ineffective. It doesn't preclude that from happening. There's still constitutional protections. And that's the case here. Trial counsel did in fact secure partial acquittals for Mr. Barnett, but I believe that those acquittals speak to the weakness of the state's case. And had trial counsel done what he testified he intended to do at the post-conviction hearing, which was namely not file a suppression motion of the defendant's confession, but rather use it in his cross-examination. Well, when he turns around and he doesn't use it in his cross-examination, it doesn't make sense that that's then strategic now too. And so for the sake of argument on the 3rd issue, if it is taken as true that that trial counsel's decision not to file a motion to suppress the confession in this case was strategic, again, it can't be strategic for him to turn around and then not use it in his cross-examination. And at the post-conviction hearing, trial counsel testified his theory, his trial strategy was, let's see what happens. And he later testified that the only thing he could argue was that when Mr. Barnett was confessing, he was confessing to stuff because he was high and hungry. That was the defense, basically. And trial counsel, in his opening statement, his defense is asking the jury just to hold the state to its burden. Now, that's fair, but he goes on and he calls Mr. Barnett a crack addict in his opening statement. And he says that the crack has taken over Mr. Barnett's brain. So he's clearly set up this idea that Mr. Barnett being high is a problem. And he states to the jury that Mr. Barnett's confession was, quote, "I probably did it. I don't remember. I've been high for days." And this opening statement, again, it sets the stage for what the jury is going to see. But what it ultimately happens is that he makes empty promises because he doesn't go back and do that. And it's not just that he didn't do it that grants relief here. The problem is that he didn't offer a reason for turning around and not using it. In fact, what he testifies at the post-conviction hearing is that he thought he did ask about it. So he clearly had the intent to use the confession and clearly thought that he did. But I have gone back through the record. I have gone back, search, find. I have read it. I cannot find anywhere where he does in fact use the fact that he's high in his confession in cross-examination, especially on the most important witness, Mr. Leatherwood. And what's worse is that the state of Tennessee, in its direct examination of this officer, it preemptively attacks this defense. And what Detective Leatherwood testifies to on direct is that Mr. Barnett stated he was using crack. So it's now in there. It's in front of the jury. And the defense needs to make a move, right? That's what we do with cross-examination. And further, through Detective Leatherwood, the direct examination, the state was able to get out that Mr. Barnett appeared coherent. And again, despite this, there's no cross-examination on the issue. So the defense trial counsel has said, it's a strategic choice, at least what the trial court found, was that it's a strategic choice for me not to seek this suppression. And I'm going to use it in my defense. To use it in his defense, he either needs to put on proof or he needs to cross-examine. And he doesn't do it. And in fact, he thought he did. And it's really the fact that he thought he did it that really is I believe, the crux of this and is very telling, that he knew he needed to do it, and he just, for lack of better explanation, he forgot. I did not conduct the post-conviction hearing. I'm only appointed here today, so I am, looking back as well as this court. But when trial counsel doesn't offer a reason for not then doing what would have been considered strategic, and in fact he believes he did do it, I think it's very telling.
So you didn't conduct the PC hearing,
Correct, Your Honor.
but that's still, my question still would be, who was called at the PC hearing to show if you'd called this witness? I mean, did the PC counsel call witness X and ask the questions that you're claiming trial counsel should have asked?
No, here's what happened, Your Honor, is that trial counsel was called, and post-conviction counsel at that time intended to call the officers. What happened is that he did not, I believe he subpoenaed them, but he did not actually call the officers and guarantee that they would be there, and so they were not available that day. And the court said, well, we can do this in a piecemeal fashion, and at the end of the hearing, post-conviction counsel had decided they weren't going to go another day. And so that's all I can really speak to on that particular issue.
So then how do we judge what would have been testimony if we've never heard the testimony?
I think really
Because
just...
the police officer could have said, I'm sorry, but the police officer, if you'd asked him, well, was he high or whatever the questions may be, and he was, no, he's completely normal. Well, I mean, we don't know. Or he could have testified, oh yeah, stoned out of his mind, had no idea what was going on. We don't know. So how do we judge counsel's performance if PC counsel didn't give us a record to judge it against?
And I think what we can look at is what the same detective did testify to at the trial, which is that on direct examination, he states himself that he believed he was high. But then he goes on to say he believed he was coherent. And so it's the fact that he did not then cross-examine him. Cross-examination is the most important tool we have as a criminal defense attorney. Our clients don't have the burden of proving their own innocence, so we oftentimes are not putting on our own case in chief. Our main tool is cross-examination. So by just not doing it, I don't think there can really be any real excuse for it or any strategic move, especially when then you turn around and the post-conviction trial counsel says he thought he did in fact do it. And that's what's really the most troubling, is that he clearly had an intent to do it. And there is testimony then that Mr. Barnett was high. It's come out, and there's been no defense made against it. There's been no cross-examination. Trial counsel did not test the strength of the state's case by cross-examining the officer about it. And so we do have an idea that Detective Leatherwood would have said, yes, he was high, and that we could extrapolate from that there would be some indicators of that. And that could be what Mr. Barnett's statements were. That could have been his observations. There is a video that was played, and I think there are some observations that can be made from that video. And we have asked the court to take judicial notice of that. And so, in fairness, if you watch the video, he is fidgety, kind of slups out a little bit at times when he's alone. So there were things that could have been asked, and I do think that just by the very nature that on direct examination this officer did talk about the fact that Mr. Barnett was high, I think that's enough to assume that there would have been testimony that trial counsel could have extrapolated from that. And if I may now, I'd like to turn to the first issue, which is about whether trial counsel had adequately investigated the case. And the real problem here is that Mr. Barnett testified he had had fluids of some sort taken from him when he was brought in and taken into custody. And they were never tested. They were never looked at. And what's troubling here and what really makes it deficient is that if trial counsel, after all the diligent work he did in looking through this case and all of its discovery, as he testified that he did, and that the post-conviction court found credible, if the only defense theory he could come up with was, I've got to use the confession because he's high, it only makes sense to go and get all the other evidence you can. Go get the evidence, get it tested, get an expert to come up and testify to it.
What evidence are you talking about?
This would be the evidence that Mr. Barnett says he had fluids taken from him, blood, urine, and those would be tested.
Do we know that at the time that this lawyer was involved that it even existed?
I have not been able to determine that, and the only thing I can tell this court is that by reviewing what Mr. Barnett testified to at the post-conviction hearing is that he had fluids taken from him, including blood and urine, and the trial court found that to be.
We have no evidence of that other than the defendant's statement.
So there's no record.
It's just speculation.
And that's part of the problem, I think, is that because trial counsel did not go and seek this evidence out, when, again, if it exists, and I believe that it did.
Well, yes, but did post-conviction counsel go and search through the police records to see if they sent blood or urine off to be tested on this individual? Did he subpoena TBI crime lab records? I mean, did he do any of that?
Based on the record, that did not occur. And so, again, that is troubling that this information was never sought, especially, again, when after looking at everything, when you decide your only defense theory is for this. And what trial counsel testified to at the post-conviction hearing was that he didn't see any reason why he should go and get it. If it wasn't provided in discovery, it must not be important. And so I think that it's the fact that you don't go and investigate the one thing you think.
On the other hand, allegedly the defendant was so high that he didn't know what he was doing anyway, so who knows?
I think that is fair, and but that's the problem, is that if that's your one line of defense, to not go and seek it out is a problem, because now I have to stand here before this court and say, I don't have it. And I understand that's a problem, but that's where we're
The problem
at.
seems to me that this is different from a case where you have a defendant that gives a written confession. And, you're saying the defendant was high and he didn't know what he was saying. You have a video that counsel had seen, that the jury would ultimately see, and the jury ultimately used to convict him. And that seems to be, like you said, you can infer from his actions and his speech in the video where he was too high to know what he was saying. That seems to be the difference in the case to me.
And again, you have to look at the video, and so, and kind of tying in with what the second issue is about, trial counsel not filing a motion to suppress, I know it's a harder burden once you say the only line of defense we can use is the confession. But I think that even when raising that as an issue, it really highlights just how bad it was that then he did not do what he said he was going to do and use the confession in his defense, especially when he thought he did. I think that's what really highlights about issue 2, is that if you say it's strategic and you had nothing else, okay, but you didn't do it, you didn't follow through, and that's a problem. And even though there were some acquittals in this case, I think, again, it really just speaks to what the strength of the state's case was. Unfortunately, I have a lighter record than what I would like if I had handled the case. But I think what we can see is that it's not really a cumulative effect, but it is a domino effect. And by not investigating, you found your one theory of defense and you didn't even check if those things actually did exist from what we can see. And that was because he believed if it's not in discovery, it must not be important. Well, maybe it's not important to the state's case, but it seems like it's pretty important to your defense if it's the only defense you have. You need to go in there with everything you can. At least find out if it does exist for this particular case. And that kind of goes into the motion to suppress. Had he done that, and we did end up here today with toxicology that showed that, my example would be if it was a blood alcohol level of, like 0.32, that's 4 times legal limit. That's something we can all kind of understand the level of. Even if you look at that video and then you have toxicology results in front of you that are, say, 0.32, you're going to question, you're going to look at that, a jury is certainly going to look at that differently, and it's going to give you grounds for that motion to suppress. So it starts at the beginning, and we get all the way through trial where even if it was a strategic decision not to file that motion to suppress, he didn't follow through with the one thing he said he was going to do. And if there are no questions from the court, I would yield the rest of my time.
Thank you, counsel. All right.
Good morning, Your Honors. Abigail Renard for the state. I think it's important to consider this case in the overall context of the case. The state's proof here was overwhelming. The petitioner had 2 separate cases going on. There was this case with the aggravated burglaries and a set of business burglaries as well. In this case, the petitioner was caught either inside the house or on the porch. He had personally pawned several items from prior burglaries. The state's proof here was overwhelming, and then the petitioner went on to confess. And yet, the trial counsel here was able to get 4 acquittals from 4 separate aggravated burglaries and felony theft charges. And I agree, while that's not dispositive, and certainly, had trial counsel been ineffective, that it would still be a problem, but it's much harder to show prejudice given that his trial strategy was so successful when the state's proof was so overwhelming. So first, addressing the cross-examination issue, the petitioner here also testified repeatedly during his own testimony that his attorney did an awesome job, was a really good attorney, and was very successful. So the petitioner ultimately also thought that his attorney was fairly successful here. And his cross-examination, again, the jury here saw the video of the petitioner. The detective testified on direct examination that the petitioner was high. There was no real question that the petitioner was high. Everyone was kind of on the same page and realized that. And trial counsel made a decision to argue that the petitioner was high. He didn't need to elicit more on cross-examination about that, and he testified at the post-conviction hearing that he didn't see the value in attacking law enforcement officers, particularly in Knox County. He said that he had found that that was not a particularly good strategy to take in that county with those jurors. And so he still argued it. And there is evidence that he did cross-examine the witnesses. It's not that he, just sat there, didn't cross-examine at all, didn't bring it up. He did cross-examine them, not necessarily specifically about whether or not the petitioner was high. And again, everyone kind of agreed here that he was high. The jurors watched the video. As counsel pointed out, there's, some evidence in the video that the petitioner was high. So eliciting additional information about how high he was, it's not clear how that would have helped the petitioner here and how that would have changed the impact of the trial given how just overwhelming the state's evidence was. And so the petitioner cannot show prejudice here, even if he could show deficient performance.
To counsel's question, counsel's statement that he had been told, or he knew, I should say, Knox County juries love the Knox County Police Department and they're trusted and this, that, and the other. And I understand, as a defense attorney, you kind of walk this thin line between, really challenging the state's case and being the most hated person in the courtroom, because if people don't like you, they're not going to like your client. That being said, how hard is it to ask a police officer on cross-examination, was my client high?
It's obviously not difficult, Your Honor, but I think that question had already been answered. And I don't, even assuming that it was deficient performance here, there was nothing to be gained by asking that question, which also goes to why it was not deficient performance. The detective had already testified that he thought the petitioner was high. The jury saw the video and could reasonably see that the petitioner was high. There was no question here that he was high. And so additional cross-examination about that issue would not have done anything to help the petitioner here. And related to the confession and counsel's decision not to file a motion to suppress, a motion to suppress here, number one, would not have been successful. The test for whether or not intoxication or drug use invalidates a confession is whether or not the defendant at the time is capable of making a coherent narrative of events and stating his participation in the crime. Here, counsel found that he was, and the post-conviction court found that he was. He was able to talk about his participation in the crimes, he was able to talk about what he did, and there was no legal basis to file a motion to suppress here. It would not have been successful. And even had counsel filed a motion to suppress and been able to somehow get the confession suppressed, the petitioner cannot demonstrate prejudice because it likely would have had a negative impact on his case, let alone, changed it to make it more favorable. Here, counsel was able to very successfully argue that the only reason the petitioner was confessing was that he was hungry, he was tired, he was high, and that strategy worked. He was able to get several acquittals, and I think that, really goes to the strategy here, is that it was helpful to him to have the confession in. And so because there was no legal basis for suppression, he was able to successfully use the confession. It was also not objectively unreasonable for counsel to not file a motion to suppress here. And then finally, turning to his investigation of the case, again, to the points that have already been made, there's no evidence here that the blood and urine samples actually existed. The petitioner says that he had samples collected of some sort. Trial counsel testified that he vaguely remembered hearing something that perhaps the petitioner had told him that samples had been collected. It's not clear from the record whether at that point there were any samples in existence. It's not clear that, there would have been any testing able to be done. And even if there had been testing, there's nothing to really be gained from proving, again, even more so that the petitioner was high. Everyone already agreed that he was high, and it wouldn't have rendered his confession invalid because, again, he was able to make a coherent narrative of events. And in regard to the testing on the cigarettes, trial counsel noted that even had the cigarettes been available for testing, he wouldn't not have chosen to test those cigarettes because it could have resulted in an additional drug charge, so it was very reasonable for trial counsel to not seek testing of the cigarettes in that instance. And if this court has no additional questions, we ask that you affirm the denial of post-conviction relief. Thank you.
All right, Ms. Boland?
The state says that this was overwhelming amount of proof, but that's obviously not the case when there are so many acquittals. And I think it's important to look at just exactly which counts the jury did acquit on. For one of those, actually, counts 3 and 4 as to victim Perkins, there is actually a statement by one of the testifying officers that they couldn't find any pawn shop activity. And even though there was testimony about it from a victim, it was only Mr. Barnett's confession that connected him to it. And so there's a guilty on that. So had his confession been thrown out, I think there is proof that the jury would have positively impacted his case, not negatively. And additionally, on the counts 9, 11, 13, 15, 27, 28, 29, and 30 that were not guilties, the officer testified that he had located at pawn shops transactions that victims positively ID'd as their property and were linked to Mr. Barnett's ID. And yet they still acquitted on those cases. So on those particular counts. So I don't think that there's actually this overwhelming amount of strong proof when the jury was willing to acquit and find guilty on those particular counts.
But the exact opposite of that argument could be true, that they required overwhelming proof rather than just proof beyond a reasonable doubt on the counts that they did find him guilty.
But we don't know. And so, but I think that that's important. And it's, as to what the state said about the fact that he's high, that's not contested. But the point is, it is to the extent he's high, because if you have a video where he seems coherent, then and your only line of defense is he's high, go find the evidence that your client is telling you exists. And if you don't find it, fine. But to not even make that inquiry because you said it didn't come to you in discovery, that's deficient. And I think that prejudice just continues to roll in domino effect into this entire case. And as for trial counsel's decision not to attack the officer, that because Knox County likes officers, I think the court is correct that it wouldn't have been hard. And in fact, the officer's already said he was high. He's being agreeable. That's what we want on cross-examination. We want yes answers. And so he's already being agreeable. He's not being hostile. And you intended to do it. So much so that when trial counsel testified at the post-conviction hearing, he thought he had done it. And he did not. And that is the real heart and real problem of this entire case, is that if everything else was strategic, to turn around and not do the one thing that you needed to do, that you said you were going to do, that was your strategic decision, to not do it and say, I thought I did do it. He didn't say, oh, I made a decision actually after I thought it was going to hurt the case. No, he thought he did in fact do it, and he did not. And that is the real problem. Briefly, as far as the fact that having the cigarettes tested could have resulted in another charge, a simple possession charge in the face of 30-something felony theft and aggravated burglaries is not much, a misdemeanor. And so I think that, that's a conversation obviously to be had with your client, but I think that that's not a very, I don't think that argument has a whole lot of merit to it, just in looking at what he's charged with versus, okay, if you get it tested and you've got simple possession. I don't think this was overwhelming proof in this case. We see that by the acquittals. And just the fact that there are acquittals doesn't mean that there weren't problems or that trial counsel couldn't be ineffective. And just because we call an attorney ineffective, it doesn't mean we're marking them as a bad attorney. That's not what any of this, it's not a punishment. All we are doing is making sure that the defendants who are represented have constitutional, effective assistance of counsel like they are guaranteed. And just because you win, it doesn't mean you were not effective. And it's the same reason, just because you lose doesn't mean you were not effective. And so we have to look at everything, and I think what it really boils down to is if everything else was strategic, if it was strategic not to get the suppression motion and test the other evidence that may or may not exist here today, if that was your strategy and you don't follow through on it, you have been deficient and you have prejudiced your client. Thank you.
All right. Thank you, Ms. Boland. Thank you for taking the appointment to handle this appeal.
Thank you, Your Honor.
All right, that concludes the cases. I'm going to call out once again Julia Trant. All right, let's talk about what we need to do and come back at 1:30 with the clerk's office.
All rise.